Hello, my name is Justin Bell, here with the Bell Law Firm, and today we want to talk about it's a key thing in most cases. It's called probable cause, okay? And we want to talk about why it's important, what it means, and how it can affect the outcome of your case. And first off, probable cause, that is a level of proof, okay, and it's distinguished. It's defined as more likely than not. So that means that if you have evidence and one side tips the scale where it's more likely it happened or more likely it didn't, that's what it means. Some people will say it's 51% this. It's not even that. I mean, it can be a 0.01% more. So anyways, all it means is that whoever is making the decision, who is the trier of fact, whether it be a jury or a judge, the level of probable cause means that whatever evidence that's presented, it's more likely that one way it happened or it didn't. So what does that mean to your case? Well, it's usually the most critical factor that drives a case, whether someone's going to be convicted or their case is going to be dismissed. Okay, and so let's talk about how probable cause and an arrest coincide. Okay, for an officer to arrest someone, they have to, in their mind, believe there's probable cause that a crime occurred, okay? So that officer, he may believe that probable cause exists, but just because he does believe that doesn't mean that it's true, okay? So let's talk about what that means. For an arrest to be valid, probable cause must be established, okay? So I'm sure a lot of you out there have heard recently these news outlets that have been covering a lot of different law enforcement agencies all throughout Tennessee have arrested individuals for DUI, and then their blood results come back and they have absolutely nothing in their system that could cause impairment. Now, these numbers, they've been staggering, okay, just in what they have shown when people come back and they have nothing in their system. But what they haven't told us is all the different people that have also been arrested that may have something in their system that could potentially cause impairment, but it wasn't to the level of impairment. In Tennessee, when it comes to alcohol, there is a per se level that if you are found to be operating a vehicle and you have 0.08 or higher blood alcohol content, then you are per se impaired in the state of Tennessee. Okay, so now, but if you're operating that vehicle under the limit of 0.08, can you still be arrested? Yes, you can, if you're deemed to be impaired. Okay, but here's the thing, and I remember back when I was in law school, I interned with Senior Judge John Kerry Blackwood, and we were at a trial. I think it was on a vehicular homicide case, and I remember him talking to the jury. Okay, and he gave them instructions. He said, "Jury," he said, "a lot of you've heard this, throughout your life. It's don't drink and drive. It's illegal to drink and drive." But he said that's not true. He said it's not illegal to drink alcohol and then drive. It's illegal to drink over the limit and drive. Okay, so that's something that we need to keep in mind as we're talking about this, and why probable cause matters. Okay, because here's the thing. Let's discuss a situation where probable cause was not established for an arrest, but an officer arrested someone anyways. Okay, let's say that a situation arises where someone said it smelled the odor of alcohol, wanted someone to get out of an officer asked the person to get out of the vehicle and asked them to perform these field sobriety tests. Well, first of all, these officers are supposed to question people as to whether or not, and assess them medically to determine whether or not they're an appropriate candidate for those standardized field sobriety tests, because not all people are. And if you're not a candidate for those tests, they do have alternative tests that can be offered. But anyways, these tests, they are not mandatory. You're not required in Tennessee to perform these tests, okay? And frankly, these tests are so difficult, all right? It would take a skilled athlete who really already knows what clues the officers are looking for, all right, in order to perform this test and do well on it, okay? So, so let's say we have a situation where someone has medical injuries and that they are not a good candidate for these tests, and the officer asks them to do the test and then they decline. Well, usually an officer is going to just say, okay, well, I'm going to arrest you, right? And and then they'll threaten them and say, read them this implied consent, all right, where it tells them that probable cause has been determined to exist. Well, only by that officer. It hasn't been determined by a judge in a court, okay? And it hasn't been scrutinized by a defense attorney, all right? So there's many officers that have arrested people, and certainly clients of mine, where after we've had a preliminary hearing, I have taken them through the steps and exposed them so that the judge then can make a determination whether probable cause exists. Okay, so if probable cause has not been established, then the arrest is invalid. So let's talk about what happens if you have you do give blood and that comes back and it indicates that you could have been impaired while you were operating that vehicle. Okay, does that mean your case is done and there's nothing else to do? Absolutely not. All right, like I was saying, what determines and drives a case as to whether or not someone is convicted or that case is dismissed is whether or not probable cause was established for the arrest. Okay, if it's determined that probable cause did not exist, then that arrest was invalid, and then the blood is invalid and should be suppressed. So therefore, that case would likely be dismissed. So that is why probable cause is such a critical thing, okay? And it's imperative that you have an attorney that's going to attack that probable cause and scrutinize it in every way, with that officer on the stand, okay? So if probable cause is determined that it wasn't there for the arrest, it's very likely that case is going to be dismissed, okay? And that is why you have a preliminary hearing, because that's the whole purpose of it, is that judge is there to determine, based on the evidence that's presented, whether or not probable cause exists. And if probable cause is determined that it was not present and it wasn't valid at the time of the arrest, then that judge is going to dismiss that case, okay? And he will not bind that over to the grand jury. Now, the state does have the option to present that to the grand jury, but it's usually not going to happen. The grand jury, the defense can't even be present. We have no idea what's even been told to them. My experience is I've had cases where they were charged as a felony. We had a preliminary hearing. Evidence was presented to show that it absolutely was not a felony, and it was amended down to a misdemeanor. Then later, the state presents the case to a grand jury, okay, and then it comes back out of the grand jury indicted as a felony. And it was a theft charge. So, and the critical information is that in the warrant, it was alleged that the amount was over $1,000. But at a hearing, the key witness presented evidence that no, in fact, it was less than $1,000. So therefore, it was unequivocally, it was a misdemeanor. So when that case came back out of the grand jury as a felony, that told me the state didn't give them the evidence that we brought out at the hearing. They brought somebody in and read the warrant, or maybe gave the warrant to the grand jury. I don't know. All I know is they did not present the evidence that their own witness gave at a preliminary hearing. So that tells me, hey, grand jury ain't much. All right, it's whatever the state wants to present them is what's going to come out. So so we really don't care much about the grand jury, because one, we have no idea what they're even being presented to them as far as the evidence. So that's why I think that it's very important to take advantage and utilize the right to have a preliminary hearing, because you can win your case right off the bat and save your clients a lot of dragged out continuous court appearances, and even going into a trial to determine whether or not they're going to be convicted of a crime. So anyways, hopefully this helps to explain what probable cause is, what the level of that burden of proof is, and also why it's important. It drives all criminal cases. It drives whether or not someone is likely to be convicted of a crime, or that case is going to be dismissed. So hopefully this helps explain what probable cause is and why it's so important.